Thank you, Professor Alexander. It is my pleasure now. It is my pleasure now to introduce our first speaker, Professor Anita Bernstein. Start over. Thank you, Professor Alexander. It is my pleasure now to introduce our first speaker, Professor Anita Bernstein. Professor Bernstein is Juris Doctor by the University of Yale. Currently, she is professor at the Brooklyn Law School in New York. Professor Bernstein is a nationally recognized authority on tort law and feminist jurisprudence, as well as professional responsibility, products liability, and family law. Her awards include the first Fulbright Scholarship in European Union Affairs given to a law professor. As a member of the American Law Institute, she has served as an advisor on two tort restatements, the recently completed one on intentional torts and the in-progress restatement covering remedies. She will be talking about the heart of tort. Professor, you have 30 minutes. Excuse me,
Professor, it's only 20 minutes. Sorry. Thank you very much, Mr. for my interruption. Before my departure to attend my foreign duties, I would like to invite our guest professors to visit the university president office to have a cup of coffee and also to share a chocolate bar at any time at the president office at the university. Also, I would like to invite you to enjoy our campus, the forest, the gardens, and we are very proud about that. So welcome again. Good luck for this discussion. Thank you very much.
It's open, so
The video camera.
yeah, it's open.
Okay, I'll do my best. Thank you very much for the kind introduction. I know that a lot of work went into this event, and I want to acknowledge all the unseen efforts that made the experience so pleasurable. Thank you to the Alliance of But I'm sorry, I don't know. I can either stay here or sit down.
Yeah.
I should stay. Okay, I'll go. The first speaker is the batch of brownies that you throw out when it burns. So I'll do what I can. I wanted to express my appreciation for the invitation to join the second international workshop of the Network of Philosophy of Private Law, the Alliance of the University of Girona in Spain, Adolfo Ibanez in Chile, and especially here Externado in Colombia, have put together an exciting presentation. I have called this talk "The Heart of Tort" as a kind of placeholder name. I may not stated it. What I would like to do is talk about two papers of mine that were previously published a couple of years ago. I'll give a presentation on each, not as long, I guess it would be if they were isolated. And then at the end of my half hour, talk about the possibilities of a new paper that takes into account the ancestry of the other two. The metaphor I've used, the children and families, they tend to look very different to their parents, but outsiders see resemblance. So if you think of what I've done as a parental effort, I think, well, the first paper is an angry feminist lament that presents private law, and the second paper thinks it's all cool and logical and calm, and I would never dream of getting having any feelings or being emotional. And I suspect that this distinction is overdrawn. There probably are commonalities between the two papers that perhaps you can hear when I talk about their content right now in these remarks. The first paper is called Private Law as Unjust Enrichment, and it argues that the premises and ideas of private law necessarily work out to leave women in some respects worse off and to advantage men. So I see a kind of zero-sum a struggle. Guadalupe Martinez has talked about the role of the initiator, the complainer, as an actor in private law. And I'm interested in this idea. Diego Javianes has written about the social subordination. I think these are two kind of cousins to continue the family member here in the room. Ideas that are present in other people's works, I think, overlap with mine. Private law will not happen, the apparatus will not be turned on, the machinery will not work unless somebody stands up and says, I am aggrieved and I want what I want and I demand what I'm entitled to. And then in response, the accused person, the defendant, digs in and says, I want what I want, you can't have what you want. And on the first page, I'll just skim a bit of it out, a couple of roles or ideology, identities, I guess I would say, that the private law player must be. Private law player, the person who enters the private law system, demands attention, says this is not just my problem, it's your problem, it's everybody's problem. Listen to what I have to say. It's not only personal. And the attitude, if it appears exaggerated or not in proportion to the entitlement of the speaker, may seem selfish or arrogant if we don't like the push. The claim of a private law participant is also on an advocate demanding the loyalty and attention of a lawyer. That is not entirely related to the amount of money paid or to the amount of talent that lawyer has. The private law player defends boundaries. It says you crossed a line. This is an idea of Arthur Rich Hughes. I think the idea of being pushed around or harmed by the interference of another, and all of this content, this stance that is spoken by the private law litigant is pretty aggressive. You can't just get there by receiving government welfare benefits. Nothing is handed to you. And lastly, this person has failed to cooperate and negotiate. The fact that we know about him or her in decisional law or reported episodes of litigation means that that person did not swallow, did not suck it up, did not endure passively and patiently, but refused to yield and is on the attention of a judge. From there, I think that the background that we as adults bring to our entitlement to complain about an injury or to resist an accusation by another is influenced by where we come from. And here I know I'm outside of my home country. This is the problem. I'm rereading these papers for this workshop. I thought, you parochial American much? I'm not entirely universal theorist as maybe should be as a speaker here. So some of what I have to say is about the United States. I do think that the subordination of girls and women is not peculiar to the United States, and that similar antecedents in upbringing happen to girls and women around the world. And so I just reviewed the evidence for different treatment of babies, even regarded as boys or girls when they're young. When you enter the toddler age, being 3 or 4, you start having mass attainment marketed to you. That also sends out messages of acceptance and subordination and passivity for female people, and being an initiator and a go-getter, that practical honesty, we'll rely on it later. Those are traits that are conveyed and encouraged in men. In schools that have been studied in the United States, I don't know the evidence from outside of my own country, but observations show that teachers interact differently with boys than girls, and sometimes in a harsher way. Sometimes boys are punished more than girls, but what unites the treatment of these two genders in the classroom is a kind of deference and not deference, I shouldn't put it that way. The teacher will proceed as if what the boy is doing is important, make his punishments even more public and scandalous than the punishments of girls. Parents, at least in the United States, give their boys more money than girls. The allowances, that's the rental stipends to children are about twice as high for boys as girls. I know in my country, parents will bribe or pay their sons to take showers and not do that for their girls. The chores that girls do are paid less. And this, I think, sets a template of expecting to be underpaid when one becomes a worker in the labor market. I think this is true around the world, that for most of the time, most places, female workers are paid less than male ones. So being a private law litigant, this disadvantage means that one is less intimidating, one can't buy the most aggressive lawyers. When one is offered a settlement, one might be poorer and need to take a cheaper one. And so the financial disadvantage that derives from being poorer makes an individual a weaker litigant. The history mercifully winds down. I don't go on much longer after that. After being underpaid at work, our paradigmatic female person goes home to an environment where is likely in her own household to be less entitled, less empowered to assert herself. The majority of women around the world, and in my country too, have at least one baby, one child before they die. Even larger majority of women are in heterosexual relationships at some point, including marriages. And these occasions, as you probably have heard from other people, are locuses of subordination on the whole. I wrote the hashtag not all women in the paper, so maybe I need to say that these generalizations are very crude, and there are many exceptions. I don't want to discount the hardships of the gender that I regard as advantage, but with respect to private law, when one must proceed with a sense of righteous indignation, entitlement, and refusal to yield, I think that the background of being female is a source of disadvantage. And what that means is that the law, especially in a common law like mine, but also outside in other legal systems that work in a more civilian framework, the law is shaped and influenced by male inputs more than that of their female counterparts. When Diego Papianis writes about subordination, his focus is on wealth and poverty, which is, I think, extremely important. And I regard my piece as a kind of companion with providing another axis for locus of subordination. I think that what happens is the definition of unjust enrichment. The following things must be present for unjust enrichment to exist. First, an enrichment. Second, an impoverishment. That means a lessening of wealth. Third, a connection between the enrichment and the impoverishment. Fourth, the absence of a justification for the enrichment and the impoverishment. And fifth, an absence of a remedy provided at law. For the last two, I don't think there's a good justification for the inferior position of women in the private law. And I think that not only is there no remedy at law, but law is actually a source of worsening. It's a problem. Private law intensifies and makes stronger the disadvantage that burdens women as participants in a system that demands their initiative. So that's the first paper. And now I want to move to the second one, which is, in my eyes, in my perception, a very different one. But just to sort of tell you where I think I want to go with this, when I talk about the private law unjust enrichment thesis to audiences, a comment that I've heard in response in the question and answer period is, how can we help? Or do you have anything constructive or positive to suggest? And it's a sort of softball friendly question. And I never have an answer because I'm just ranting, I'm angry with, I don't feel consciously angry, but this is an expression of a grievance, and I don't purport to have a solution. I wonder whether some variation on formalism, where the reformer or the progressive-minded individual who wants to change the state of affairs, it might look to something that appears either neutral in the sense of not being overtly partisan for one person, or of general interest. It might be the beginnings of a solution. Claims for justice usually try to enlist the conscience of the person talked to, and to ask how would you feel? Is this something that you can relate to? Do you, does my pain or my disadvantage that I'm complaining about strike you as being not only about what I want, but of what others might want as well? And so this is a piece called Q, what is tort? Categorical, her Q and A is short for a question and answer. I guess the Q part would be more recognizable if English is your second language. So it's the question, what is tort? And the answer is categorical hurt. Several people in this room have thought about what tort law is, what its nature is, what it's about, and generalize it. I think the author's book, Private Laws, is an attempt to speak about all of tort law and make generalizations about it that apply to different claims, different causes of action, and different results. All of them can be integrated. I find that ambition exciting, and I chose a narrower path here because I really was asked, what do you think tort law is? People had to explain its essence or its nature. What would you say? I have a junior colleague at my school who said, what is with you towards people? You're just so obsessed with your identity and who you are. And other fields don't do that. No, I remember what is property, what is contract. It's just at the moment, it seems to be a lot of noise and buzz around the essential nature of tort. And whether this is of interest to you or not, I don't know, but it's certainly a common pattern on people who work in my subject area. So I think we'll be hearing a lot today about the line between private and public, whether private law is entirely or narrowly private, what it means for the law of torts or any other field to have a foot in both, to care about the individual grievance that frames private law, and the collective interest that's of interest to public law. And I kind of have an echo of that here in this answer to the question. With the answer, the A and Q&A's categorical hurt. And I do not wish to go down the wrongs route that many people like. I don't want to say torts about wrong because I want to include the causes of action or claims that appear contrary to wrongness, notably strict liability. And so categorical refers to the public half of the origin. It's about what is of collective interest. Working with the idea of con, I know I'm a con amateur in this room compared to other people, so my rendering of con would be rather shallow, but the con's suggestion about figuring out what to do as a matter of ethics is to ask yourself whether what you're planning that it can be generalized into some kind of universal maxim. So a claim for everybody, inclusiveness, all persons in the community being equally in range of the idea is covered in categorical, and hurt is more of the private side. It's the pain that an individual litigant feels. And I think even when a party to a tort claim is a corporation or a business, it is still protesting what it regards as a hurt. Categorical for the matter of general interest, hurt for the claim of the individual. The evidence for my construction, I guess we're trying to find reasons to get people to agree that it is correct to say tort is about categorical hurt. The doctrines of standing and causation are ones that rely on and expect an assertion of having been harmed by the individual. It is possible from the outside to design reckonings and accountings and constraints that don't depend on the complaint, and those in that alternative scenario, the law would not rely on people protesting an injury, but instead would try to figure it out, identify problems some other way, and the legislature with its large budgets and research capacity would be the example of that. But even a TIPS hotline, call anonymously to report some kind of misbehavior, that could be another way to get the information needed to figure out problems and to come up with solutions. But tort law insists on an individual who complains about a wrong to have suffered from it, or at least be at risk of suffering in case of seeking an injunction. So you'll be tossed out of court for a failure to state a claim if you can't associate the wrong that you're objecting to, the conduct you're objecting to as a source of harm for you. Now, in my country, we use juries for tort disputes, not true in most other places around the world. And so here I'm being parochial and American in a bad way, because I know that the layperson fact finder is not the norm for this cause of action category law around the world. Even though the large majority of disputes don't go to a jury in my country, the pleadings and the argumentation and the advocacy of the lawyer is all oriented toward a lay fact finder, a human being rather than an expert in the law to decide yes or no on liability. And I find evidence for this outside the United States as well. Reasoning with another person, asking that person to side with you and against somebody else or something else is a claim on feeling and emotion, as well as on the application of a legal theory. I did a paper once on asbestos liability. Supposing years ago, and I found reasons to think that judges were feeling the pain of asbestos claimants, and that even defense lawyers were moved by the suffering and fought less hard, yielded or gentler in their resistance. So I think tort is central. I think that hurt is central. Excuse me, to tort, and that it is more than a formally checked box of complying with some kind of technical requirement. As for the categorical conduct, I think I'm running low on time, so I'll end up talking even faster, which is somewhat hard to do. A categorical is the Kantian antecedent of and the kind of public law counterpart of tort. And I want to sort of comment, maybe this is a language issue that doesn't translate to Spanish, but categorical is sort of an ironic or self-contradictory term. In English, we say flammable and inflammable, the opposite word, they mean the same thing. Apprehend and apprehension mean both loss and capture. And so a categorical imperative is one that applies to everyone, but categories are precise demarcations or subdivisions of the law. So application can be both particular and general. But the answer is yes, it can, and Kant was quite clear. I know only a little bit of German from writing. I referred to it in the paper that a classification or a concept can be both aggregative, put everything together, and also insisting on subdivisions and subcategories within that larger category. And tort, I think, because this again, my layperson version of Kant. Tort, I think, is especially good as an illustration of categorical. Even though one I think public law would be the better category, the criminal penalties assigned by scheme, distribution plans in tax law. But tort tells the individual, figure it out, gaze at yourself, because, and again, this is the United States tort law more than worldwide tort law, but even civilian tort law, it speaks in generalities. And so the reflection that Kant urged on his readers to think about the larger relevance and impact of their ideas, that's what tort demands as well. We're trying to figure out how to use reasonable care or how to avoid crossing the boundary recognized in an intentional tort. You don't have a very precise script to go by. You have to use your own reflection and thought. And so in criminal law, with the other sorts of sanctions and penalties, it asks less, I think, of the individual. One who knows more about this than I, but I think the criminal law is more precisely prescriptive than tort law. Yet tort law is prescriptive. It does tell people that they'll pay for the harm they cause if they do it. Now, those are my arguments in favor for a categorical constituent to tort and also hurt involving the pain of an individual. Now, with only 1 minute, I don't have the answer to the question, having the two papers fit together. I'd be very thankful if you can find me online or here in Bogota. And if you have suggestions on how the these two papers seem to have commonality. I'd be very grateful to hear about that. The preliminary thought on which I'll conclude is that the claim of injustice that I'm asserting in the first paper is one that calls on people who are not affected by this detriment to sympathize and engage. And so I'll be interested in Diego's ideas about what to do about the problem of social subordination, trying to ride along with his prescriptions and suggestions. Make it possible for other people to understand the wrong or the hurt that you are experiencing. That seems to be the only way forward to get the kind of change that I would like to see. Thank you.
Thank you, Professor Bernstein. Especially for, of course, for your wonderful lecture. Now we will open the floor for questions from the speakers and the public. Do we have any questions for Professor Bernstein? Maybe you can raise your hand and I will get a mic. Professor Bernstein. Thank you.
Hey, thank you for the presentation. I enjoyed it a lot. I enjoyed the first paper. I was not able to read the second one. I didn't have the time, but I have two questions or two comments maybe to start the discussion about it. The first is about the idea that litigation is aggressive, and also that in litigation all the deficits or all the inequalities that are pervasive between men and women in our societies are reflected in litigation. But at the same time, I read some papers some time ago about poetic justice in cases where victims of sex trafficking were able to hold the wrongdoers accountable. And this had a very strong expressive meaning, or was important that the person that was treated as property now were able in a civilized process to demand from the others to do something about what they have done. So I think that at the same time, it's not all negative. It's true what you say, I think, but there is another side that might be positive because allows for some, I don't know, allows for an opportunity to balance things between men and women. The first. The second is just a comment about the idea that there is what is your positive pieces about this? How can we solve the problems of unjust enrichment? I'm wondering what you think about judging with gender perspective. I read a case in Argentina many years ago, more than 23 years ago, I published a piece. And it was a case in which an older woman got in love with a younger man. And this younger man led her to celebrate some transactions, conversion transactions, that were detrimental to her. And after the man won all that he wanted to win in that relationship, they split. So the woman sued him under something similar than as unconscionability. She argued that that was a case of unconscionability because she was in love, she was vulnerable in that situation, and the judges say, okay, it's completely understandable that in that situation, the person that was lonely, that was feeling alone, that was in need of some affection, that would celebrate some contracts that were not good to her. But if you read the unconscionability provision in the civil code, it doesn't fit exactly in the situation, because she was not an expert. She knew about business. She was not someone with some weakness, intellectual weakness, or she was not in necessity in the traditional meaning of necessity. But now I remember that case, and I say maybe from a gender perspective, we should interpret that it was a case of unconscionability, and in this sense, there are some remedies that can be implemented that give us better results than we normally have. Okay, this is, thank you.
Thank you. Those are very, very, very interesting remarks and questions. I am gratified to invite people in the room. I know we're streaming and not everyone has this pink sheet of paper that I handed out. But what I have on the second side of it is responsive to some of what you said, Diego. So with respect to your first remark or question about litigation enlisting aggressiveness, demanding a lot by way of assertion on the part of the individual, I understand you to be saying that yes, that is a burden, maybe a threshold or a difficult hurdle to overcome, but the rewards, the satisfaction at once having prevailed would make the struggle worth having waged. And so I wrote on the back of this would have been the third slide. I had a slideshow. And I say, assuming we keep private law. So that's kind of what you're saying as well. You don't want, it's the rhyme in American slang, or the expression is mend it, don't end it. I don't know, translates it into Spanish, but repair private law rather than abolish it. And one response that be consistent with what you're saying about the sex trafficking plaintiffs or complainants is to support or encourage or underwrite this assertion when make it easier to be a complainer. And that could involve a multiplicity of influence and investments, but could be cash money, could be support. They're trying to encourage a positive attitude rather than a negative one against or toward people who complain. But yes, I would prefer to see a world where private law was accessible rather than abolish private law and impose from above something different. I think your example about the architect case where you suggested a gender perspective on unconscionability might yield a different result. I read the American data on women as judges, and the consensus seems to be that they judge the same as men. And the reason to want more women judges or encourage the appointment or election, unfortunately, in my country, of female judges is for expression and visibility rather than to change substantive outcomes of case. So I see there's some women in the room, and I wonder, having listened to Diego's story, whether you'd like to change unconscionability to allow a woman to get out of a contract saying, I'm weak, I'm in love, I'm old, he's young, I couldn't empower myself, I want to defeat this contract, tear it up, because I'm not confident. So I'm recoiling a little bit. I did not. There were, and I won't call on anybody, but then to the men as well. Would it be a better treatment of unconscionability to create to widen it to include the weakness of social vulnerability in the age factor in heterosexual relations? I think probably I would rather not change unconscionability along the lines you suggest. I don't think women judges would go for it either, but that's just a guess based on what I've read. However, and why I wanted to mention the backside of the sheet of paper. I think you put your finger on something that's important, which is about the classification of people as, for whatever reason, not fully empowered to assert their own interests. And that's what the law calls disability. So children can't be aggressive litigants asserting their own claim, and people with disability, adults with disability also can't. And maybe this is a conversation about whether the older woman in your architect case was in some sense disabled. And if we have a more careful idea of who can't be expected to assert herself, and then think about other people who are not covered by that disability, and try to find out why they're not maybe not speaking up as much as they should. I think that would be a constructive application of your idea, and one that I would feel happier about than call that contract unconscionable. Thank you.
Thank you. I think one of the ones wants to answer, so Professor Anita.
Not, or say something else, right?
Thank you. Thank you. Thank you. I enjoyed reading your paper, both of them. And I could go through both of them. And actually, when I was reading them, I was trying to find the connection that all these
Yes.
But at first, I would like to follow up on what your discussion, your exchange with a Trevor, on the idea of the private actor. I see also an idea of private actor that is not so much into the aggressive line, but more on the idea of voice, on the idea of construction of meaning. And but we can maybe discuss it. I will I present a little bit on that. But also, I think there are some distinctions to make it more positive view of the private actor. But my main point is on your idea. From your paper, you mentioned that aggregation is a kind of the glue that allows you to break the polarizing narrative between law and economics and other subjects. And I was very interested in that because in general, I sympathize with approach to try to close the gap and have a conversation that is not as polarizing as that narrative. And so I was wondering whether this idea of aggregation actually is the one that will help you to move towards the idea of universality that actually you are trying to argue for. Because I think this is the biggest connection I see. And then I wanted to suggest, I don't know if you check Feynman that works on universal vulnerability. And actually what she's proposing, it's a concept of vulnerability that is not only layered, but that is universal. And it has been picked up in the consumer context. Again, trying to break the idea of empowerment, the idea of like weakness or representation of disadvantage of the party, but more of the idea of the vulnerability that is structural, that is universal, and that it's better addressed not in terms of categories or exceptions, but in terms of universalities that we can pick up. So I wanted to hear a little more on whether you see the connection between these two elements and whether this is the direction and you would like to go or whether this is helpful. I can then share this by Lauren if you're interested.
Thank you, Anita. It's extremely interesting. I appreciate your careful parsing or more granular look at what I said about the about private law demanding aggression. To say what it demands is voice, and a similar thing, but not only demand but reward. But one can characterize the encouragements of private law as one that would kind of welcome and encourage expression rather than necessarily demanding selfishness or pushiness in the sense of wishing to elbow the other person in the eye. Now, this is a theme in your writing in general, the struggle between the lumping and the splitting, in particular, and the general. I think anyone with an interest in private law has some kind of intellectual orientation around that problem. Which generalizations are meaningful enough to be true, which are destructively unifying in the sense that they're putting together that which ought to remain separate. As for Martha Feynman, she was my colleague at Emory, and I worked to hire her in 2003. So, and her vulnerability project is one that I've known about for a while. I think she's right. Feynman is right, and to say that we're all vulnerable. The idea that Feynman talking about her own experiences as a wife and mother, and she has 4 children. So from an early stage in her adult life, she was made aware of the problem of a child. And I think children are a problem to libertarian thought and all kinds of ideal type generalizations about what people are and how they can be used rather than used. Yes, we're all vulnerable. We're all going to die. If we're not disabled, we will be soon. We will need help. My mother moved to a nursing home at age 96, and I watched this book, which is the toughest, most vital person I knew. And so I think this is true. The problem, though, I don't know whether if you're on the advantage side of the gender line, you can think that this will be me. Knowing that your condition is likely to be lifelong and recognized forever. So I guess it's an open question, but whether the vulnerability piece would solve the problem. Definitely worth thinking about.
Thank you, Professor. Of course. Professors.
So thank you for this, Anita. And you asked for suggestions about how to combine them, and I'm not sure this is a suggestion about how to combine so much as an observation about something they have in common that might be relevant to your efforts to combine them, which is that they seem both papers are almost exclusively plaintiff focused. On the one hand, and this is in fact is what raises Diego's example so forcefully, because the first paper is about the plaintiff asserting themselves, and the second paper is about the plaintiff suffering something. But of course, when there is a tort, there's always a transaction of something happened to the plaintiff. It's that somebody did it. And I think the thing that makes Diego's example so interesting, flip it around, flip the gender roles around. And I'm not saying I would be in any way happy with this, but my prediction would be that a court would immediately describe the older woman as manipulative because of gendered stereotypes, because of pictures of, as it were, standing on their rights too aggressively. And so I think that's just something to think about in thinking through how they fit together. So too with categorical hurt. I know you say you don't want wrong, you want only hurt. But of course, a hurt is something that happens to someone, and a wrong is something that someone else does to that person. And obviously, we can have a longer conversation about how to think about strict liability in relation to wrongdoing, and we have to keep right away from that conversation to distract us. But the basic thought, it seems to me, is that if you think about it more transactionally, it may be that you'll get a clearer picture. Let me just give you one illustration. This is something that came to mind when I was reading the first paper. My colleague Mayo Moran, in the book Rethinking the Person, talks about all of the child allurement cases. And of course, most of them are cases where the child was found, where the legal issue is whether the child was contributorily negligent with respect to the injury that they suffer. And she goes through all of the cases in England, Canada, Australia, and New Zealand. And it turns out that girls are expected to be more careful than boys. And now but of course, in a small number of cases where there are child defendants, girls are also expected to be more careful than boys. But that's the same phenomenon that you're interested in. And so it seems to me that just as a way of thinking through your problem of how to combine them, you might want to look at defendants and see how each of those issues manifests.
Thank you. I have a bit of biographical reason to think that you're right, that I am focusing in a lopsided, asymmetrical way too much on the plaintiff. There is indeed always a defendant, and the defendant will always be looked at as a person and have a story told, and then externally the interpretation of the defendant's behavior asked about what that person thought, what he or she did, and what responsibilities flows from that person's choices or wrongs. What's happened to me on this issue is I have invented my own course. It exists elsewhere in the US, but it's not very common. It's legal malpractice. So it's about the subset of complaining or injury that relates to lawyers doing wrong. And it's a kind of parallel to a mandatory course on legal ethics that we have in US law schools. But instead of sanctions being imposed from the bar or the profession, they're imposed through private law. It's mostly negligence law, but not, but it also involves breach of fiduciary duty, fraud, and a few other causes of action. And I've read a course description for the next summer semester, which starts on May 28th. And I say, I have to print it down and get my, and what you're saying is very helpful to it. That most of your legal education has been from either the point of view of an agreed person, the private one. You breached my contract, you crossed into my land, if you were negligent towards me, the way the story is scripted and framed by the complaint, or it's public law where the government decides taxation or criminal penalties. I see here, even though this is a plaintiff focus course and that it's private law, we have to think about it from the defendant's point of view because almost nobody practices plaintiff side legal malpractice litigation. But in my country, stay in the private sector or earn your living through fees, you will be sued for legal malpractice. So I you and I have to grab our heads around the idea that the defendant is the star of this show. Because you need to relate to the defendant category much more than the plaintiff one, or at least equally, I guess. And it's so alien, so contrary to my cast of mind, many years, I guess, of being entrenched in the same pattern. But I think it's a very pertinent reminder for my summer teaching as well as my writing.
Thank you for this, Anita. I had a question that I thought was out of the blue, but I think I'm going to be a little closer to you. I teach both the professional responsibility class and course. It makes me think that the lawyer is indispensable thinking about how you might make progress in this problem, because in the standard professional responsibility literature, the starting critique, and there are counter punches, but the starting critique has a lot to it, of lawyers in personal injury cases that they dominate clients. So that might be an original assertion on the part of the client, which is showing up at the lawyer's office. But the client is both disabled in a fundamental way, like they don't actually know what's legally relevant, because they don't know how the law constructs the hurt, so to say, right. To speak. So the lawyer can very easily manipulate them, but they also need the lawyer's assistance in order to understand that what most bothers them may not be the way that they can articulate their claim successfully. And then the other general view is that the lawyer reduces the client's complaint to its dollar value and then simply manages the process that's driven towards settlement in order to maximize the lawyer's return, because their maximal return is very clearly not too much time relative to payout. The whole thing's extremely disempowering for the client. So I'm thinking that certain things here aren't going to change in the sense that even if clients become more assertive in willing to articulate their hurts, they aren't going to know what their hurts are, because law is unlikely to get less complex. So I was to say, doesn't it seem right to you to think we should think of this as how do we think about how the role of the lawyer really ought to be quite different from the way we standardly imagine it to be in the personal injury case? That's the place where you might make progress on this.
Yes, I agree wholeheartedly, and thank you for that. I would be interested in the non-US, maybe majority of them, in the room, if they wanted to speak to Greg or me, or afterwards in some context. I'd be grateful to know that what Greg's story about the role of the lawyer, it makes sense where you live in the legal system, from being part of it. Yes, tort law in the United States is very, I think you must be right, lawyer driven, lawyer managed. As you say, you don't even know without the law whether you're suffering is of the type that the law will care about. The rhyming old title of an article, the naming, blaming, claiming. So many cognitive steps are necessary to realize that one has a cause of action. That the lawyer is an indispensable actor. Lawyers are also a relatively discrete category. My country is large, more than 300 million people, but the number of practicing lawyers, what is it, about 800,000, maybe, the relatively manageable group. Maybe if I'm a reformer, if I want to be in any way an activist type of scholar, that would be the audience that I would want to talk to.
Thank you.
Thank you, Professor Anita. I just have a question, and it's about the idea of suffering. And when you say suffering as a part of the idea of thought, are you thinking in human beings or in physical suffering, pain, something like that? Because I understood something like it would be like empathy as human beings to see the suffering of the others in paper. But I think in this category that we have here in civil law, the moral persons, and that is a private corporation. So
I'm sorry, I didn't hear moral enterprise.
moral persons.
Moral persons, yes, right, yes.
Is
Yes.
a person who is different from natural person, human beings. Yeah, and when I think in this moral person, I don't see the suffering like experience, physical experience or human experience.
I'm sorry, Alex. I want to follow what you're saying. It seems extremely interesting, but I worry that I don't understand it accurately. A moral person is a substitute for a natural, a counterpart to a natural person. So does that mean that natural persons are not moral persons?
Yeah.
Okay. So yeah. These are only artificial, never anything but artificial. Okay, that's right. So it may seem a little bit confusing, I guess, because I want everybody to be a moral person, but it applies only to entities, right? Yeah, not human entities, right? Yes. Okay, I'm sorry, that I interrupted you.
So how suffering beats this kind of person that doesn't suffer.
Yeah. I hear parochial again. I'm of a generation that was influenced by what is called in the U.S. the tort reform movement. So the tort reform movement is a right-wing conservative shift to regard litigation as bad and need to be discouraged and ruinous for business. I don't hear this much in the United States, but I remember advocacy contending that the United States is disadvantaged in the international trade market because its liabilities so unfair dependence. So trying to sell automobiles as against a Japanese manufacturer, the U.S. has one hand time at its back because it's paying out all this tort overhead, settlements and insurance, whereas a Japanese business doesn't have that expense. I think this is sort of an engagement of sympathy or empathy on behalf of non-human recipients of that attention that was somewhat successful, and maybe part of the problem in the U.S. That in my opinion anyway, we're a very victim-blaming culture, the comparative negligence or plaintiff's fault that we just heard about can be very strict and condemnatory on people who complain as well. So maybe the tort reform movement conveniently kind of hitched a ride along a sentiment that was already there regarding people who object to behavior, claiming that they were hurt as being untrustworthy, greedy, unreliable, and the like. But for whatever reason, I do think that there's been some progress, at least in my country, maybe progress is not the right word, some gains of the efforts to engage and apply sympathy toward non-human actors, the moral actor category that you identify. If it is true, but it must be the case that feeling and sentiment are thinner and weaker for a non-human agent than a person. I just would not be ready to agree that the category of empathy or sympathy or fellow feeling, as I once called it, borrowed from Adam Smith, is one that never extends to those moral acts. I think it can.
Thank you. Are there any more questions? Okay, thank you, Professor.
Thank you.